In ADH, the Supreme Court noted that although there is a presumption of subjective fault for true crimes, this presumption may be rebutted in part by showing that the offense in question is predicated on the commission of some other offense. In today's lecture, I discuss how the Supreme Court of Canada has directed us to approach the fault requirements for so-called predicate offenses. Incidentally, we will consider its approach to the actus reus of these offenses. But before we do, let's return to the idea of symmetry. Symmetry, you may recall, refers to the notion that each element of the actus reus must correspond to an element of the mens rea. Now, so far, we've addressed this as a mere interpretive principle or rule of thumb. But in the 1980s and early 1990s, it was sometimes presented as something more than that. That is, as a constitutional or quasi-constitutional essential. This was most vigorously argued in the context of causation elements contained in predicate offenses, where the suggestion was that if, say, the completed offense required proof of, for example, causing death, there would need to be a corresponding fault requirement making reference to death. These arguments, however, were by and large rejected by the Supreme Court. Quite simply, the court has found that there is no constitutional requirement of symmetry between the actus reus and the mens rea, and certainly no requirement that if there is to be symmetry between the actus reus and the mens rea, that the corresponding fault element must be subjective fault. Now, I've used that term predicate offenses a number of times already. What am I talking about when I use that phrase? Well, in principle, the term applies whenever we have one offense that is, as it were, predicated on the commission of another offense. Take, for example, the offense of assault, causing bodily harm, or aggravated assault. Each of those two offenses is predicated on the commission of the, as it were, simple offense of assault. Likewise, the offenses of dangerous driving causing bodily harm or dangerous driving causing death. These are predicated on the commission of the simple offense of dangerous driving. The offense of unlawfully causing bodily harm in Section 269 of the Criminal Code. That's also a predicate offense, for the offense is predicated upon the commission of an unlawful act. Likewise, unlawful act manslaughter is also a predicate offense, predicated on the commission of whatever unlawful act it was that ostensibly caused death. What cases like D'Souza and Creighton, which I'll talk about in a moment, address is the question: what additional fault requirement, if any, is needed for that additional actus reus component, say, of causing bodily harm or causing death? The problem is especially acute in the context of offenses like unlawful act bodily harm or unlawful act manslaughter, because it was far from obvious in the 1980s and early 1990s that there were any limits at all on what could count as an unlawful act. The term is not defined in the criminal code, and in principle, the unlawful act could be any sort of offense, including one with no fault requirement of its own, and which on the face of it poses no risk of injury. In particular, what might help to cure the problem is, for example, in the context of an offense like unlawful act causing bodily harm in section 269 of the code, a fault requirement of subjective foresight of bodily harm. In that way, one would remove the possibility that an individual could be punished simply for, as it were, bad luck. One could only be convicted if one subjectively anticipated in advance of engaging in the unlawful act that bodily harm would or could be the result. This understanding of Section 269, however, was rejected roundly in the Supreme Court of Canada's decision in D'Souza. The court there found that there is, in Section 269 of the Code, no need for the Crown to prove subjective foresight of bodily harm. It is instead enough that there is objective foreseeability of the risk of bodily harm. Now, of course, in D'Souza, the court acknowledges that this approach to the fault standard corresponding to the causation element doesn't do away altogether with what I've described as the moral luck problem. We still treat differently the person who actually caused bodily harm from the person who didn't. And again, this may be purely a matter of luck or happenstance. But the court regarded this as unproblematic. In effect, the court seemed to suggest you create your own luck. If you engage in an unlawful act that creates an objective risk of bodily harm, and you happen to be unlucky that day, and bodily harm actually does result, well, it's on you. You create your own luck. If that seems rather harsh, though, keep in mind that one of the reasons, again, recall that one of the reasons that we're so concerned about what the fault requirement is attaching to that causation element is that it was thought at the time that the term unlawful act might be virtually limitless. It might refer to bylaws, it might refer to provincial offenses, might refer to regulatory offenses. And importantly, the court in D'Souza makes it clear that that term unlawfully does not encompass any and all offenses. The court recognizes two important restrictions on what can constitute the unlawful act for the purposes of Section 269 of the Code. First, though the unlawful act may be a regulatory offense, including a provincial offense, it must have a fault requirement of some sort. It cannot be absolute liability. And second, to count as an unlawful act for the purposes of the offense, it must be objectively dangerous. Now, in this way, the court minimized the possibility of someone being punished under the criminal code for engaging in conduct that is not, strictly speaking, criminal. Coupled with the objective foreseeability of risk of bodily harm requirement, the court seemed to ensure that only the sufficiently blameworthy could be criminally punished under Section 269. Returning for a moment to that idea of symmetry with which I started this lecture, keep in mind that, strictly speaking, the court in D'Souza does actually pay fealty in a way to the idea of symmetry. It doesn't recognize that there must be subjective foresight of bodily harm, but it does recognize, again, that there must be objective foreseeability of the risk of bodily harm. And recall, all that's necessary for the principle of symmetry to be satisfied is that the fault element for the offense pertain in some way, it must refer to each element of the actus reus. And it does. The actus reus requires proof, among other things, that the defendant caused bodily harm. The fault element requires objective foreseeability of the risk of bodily harm. So we have symmetry to some extent. It's not the sort of subjective fault form of symmetry, we might say symmetry plus, that the defendant was looking for in de Souza. But in principle, the idea of symmetry is honored here in de Souza. In Creighton, the Supreme Court builds on the reasoning in de Souza, or at least a majority of the court in Creighton builds on this reasoning, this time in the context of the offense of unlawful act manslaughter. And again, there's a problem here of symmetry. This time, the offense requires the Crown to prove that the defendant's conduct caused death. So what, if any, corresponding fault element would attach to that? Would we be looking for objective foreseeability of death? Objective foreseeability of the risk of death? The majority in Creighton says no. According to the majority in Creighton, it's enough that there be objective foreseeability of the risk of bodily harm. And insofar as the fault element attaching to, again, the causation element in unlawful act manslaughter makes no reference to death, this case is a far more straightforward rejection of the notion that there must be, as it were, one-to-one symmetry between the actus reus and the fault standard. Certainly, it rejects emphatically the idea that one-to-one symmetry is constitutionally required. Now again, concerns about moral luck seem to be particularly acute here. We're now saying that a defendant who engages in an unlawful act that poses merely an objective risk of bodily harm may be described, as it were, as a manslaughterer, may be punished as a manslaughterer, even though there was no subjective foresight or objective foreseeability of death as such. And again, another defendant who engaged in the very same underlying unlawful act, but just so happens not to have killed or perhaps even injured anyone, will be treated much, much differently. They'll be labeled differently and punished differently. And how does the court respond to that? Well, in effect, the court sort of denies the premise to at least some degree, because the majority wants to say that, look, if it's objectively foreseeable that the conduct in question gives rise to a risk of bodily harm, well, necessarily, it will also pose an objective risk of death for some members of the public. To that extent, there's sufficient, we might say, proximity between bodily harm and death that concerns about moral luck, about unfairly labeling or unfairly punishing this defendant, are at least muted. Recall that in both D'Souza and Creighton, the Supreme Court proceeded on the basis that to serve as an unlawful act for the purposes of unlawfully causing bodily harm or unlawful act manslaughter, the underlying unlawful act must be objectively dangerous. Well, the court in Javan-Marty says that that is no longer part of the actus reus. Now, why does the majority in Javan-Marty get rid of that objective dangerousness requirement? Well, in essence, the majority suggests that such a requirement is redundant in light of the fault requirement for unlawful act bodily harm and unlawful act manslaughter. Basically, if it is objectively foreseeable that conduct poses a risk of bodily harm, then, says the majority in Javan-Marty, it is necessarily objectively dangerous, and what's the point in considering it twice? It's also worth considering the Supreme Court's decidedly short decision in Godin, in which the court discussed the offense of aggravated assault. Now, the offense of aggravated assault is fairly straightforward. It requires the Crown to show, first, simple assault, and then to show that the assault involved wounding, maiming, disfiguring, or endangering the life of the victim. And the question in Godin was whether or not there is a separate fault element for that additional actus reus component of wounding, maiming, disfiguring, or endangering the life of the victim. Must there be, say, an intention to wound or disfigure, or foresight that the assault in question would result in wounding, maiming, disfiguring, or endangering the life of the victim? Are we merely looking for objective foreseeability of wounding, maiming, etc., etc.? No to all of these, says the Supreme Court in Godin. Again, all we're asking is whether or not there was objective foreseeability of the risk of bodily harm. And again, consider what this tells us about the Supreme Court's attitude to the problem of moral luck. If you engage in the underlying wrong, i.e., simple assault, and it poses an objective risk of bodily harm, you will be held accountable for any bodily harm, or death for that matter, that happens to result, no matter how unforeseeable the extent of that harm. Again, the implicit premise here is that you make your own luck. If you take your chances by engaging in an assault that poses an objective risk of bodily harm, then it's on you if a consequence transpires that you did not quite anticipate. Now, of course, all of this talk about making your own luck, it can sound a little vindictive. Maybe it sounds less harsh, less vindictive if we put it in these terms. Given Parliament's intention to recognize the significance of injuries and death in the context of all of these predicate offenses, we don't proceed on the basis that it could have intended to allow defendants to escape responsibility for these consequences by simply claiming that they didn't foresee the precise extent of these consequences or the precise extent of the injuries that might befall someone as a result of engaging in the unlawful act in question. We proceed on the basis that Parliament sought to give recognition to the injuries or perhaps death of the people who suffered as a result of these unlawful acts. And to that end, the fault requirement is kept quite low. It's also worth considering the Ontario Court of Appeal decision in Crucial, a case that addresses the offense of criminal harassment in the criminal code in section 264 sub 1. In reaching that conclusion, it seems that implicitly the court is again engaging in this you make your own luck line of reasoning. Because remember, one must have engaged in the following, in the repeated communication, in the, as it were, surveillance of the complainant's home or place of employment, etc., or engage in the threatening conduct, in the knowledge or reckless that the other person, that the complainant, felt tormented, worried continually or chronically, was plagued, bedeviled, badgered. And one must ask, if you engage in these courses of action, knowing or appreciating the risk that the complainant experiences these feelings as a result of what you're doing, well, do you really get to claim that it's just bad luck, that in addition to these feelings, they may also feel fear for their own, fear for their safety or fear for another's safety? Well, no. That is simply part of the risk you run when you engage in these courses of action, knowing or appreciating the risk that the person you're following or communicating with feels tormented, worried continually, chronically, plagued, bedeviled, badgered. It's just part of the risk you run. And if you don't want to be convicted of criminal harassment under section 264 sub 1, well, it's easy. Don't repeatedly follow people in the knowledge or in appreciation of the risk that those people feel tormented or worried continually, chronically, etc., etc. You create your own luck. Again, put somewhat differently, do we actually imagine that Parliament, in crafting this offense, intended to, as it were, provide a defense to those who say, well, I didn't know exactly how worried she was, or I didn't really know the precise extent or nature of the complainant's fears? Surely not. The Ontario Court of Appeal implicitly reasons here. Lastly, let's talk a little bit about the BC Court of Appeal's decision in Bastion. This concerns section 434.1 of the Criminal Code. And it reads that every person who intentionally or recklessly causes damage by fire or explosion to property that is owned in whole or in part by that person is guilty of an indictable offense where the fire or explosion seriously threatens the health, safety, or property of another person. So there must be an intent to cause damage or recklessness as to the risk of the damage. But the interesting question for the purposes of Bastion was, must there also be knowledge that the fire set threatened the health, safety, or property of another person. So we know that there must be an intention on my part to cause damage or recklessness as to the risk of damage to my property. But must I also appreciate that the fire I'm setting to my property threatens the health, safety, or property of another person? And the BC Court of Appeal says no. Implicitly, if I intend to set a fire and I'm reckless as to the risk it will cause damage, so I appreciate subjectively the risk that my fire will cause damage, then I'm taking my chances that others will be injured or that others' property will be damaged. Given the nature of the offense, we might say, there is an intrinsic risk of bodily harm or damage, if only to the firefighters who are called to the scene. Now, there are also strong statutory interpretation reasons to reach the conclusion that there isn't this additional fault element of knowledge that the fire must threaten the health, safety, or property of another person. Because we can consider the context. There are a number of arson-related provisions in the code. And if we compare section 434.1, which was the offense really in issue in Bastion, to the language of section 433 sub A of the code, we reach an interesting, we learn something of interest here. Section 433 sub A states that it's an offense to, quote, intentionally or recklessly cause damage by fire or explosion to property where one knows or is reckless as to whether it's inhabited or occupied. Now we might well wonder, what is the point of section 434.1 if both offenses require proof of subjective knowledge of the threat to others? Furthermore, it's significant that Parliament used the language of subjective fault for section 433 sub A and not section 434.1. So in addition to the, as it were, you make your own luck line of reasoning that is arguably implicit and working in the background in Bastion, there are sort of banal, ordinary, statutory interpretation-based reasons for concluding that Parliament intended not to have that additional knowledge or foresight element in 434.1. In this lecture, I've tried to give a, as it were, quick and dirty account of how the Supreme Court has interpreted the fault elements for so-called predicate offenses, and along the way provide at least some sense of how this approach reflects ideas of symmetry, moral luck, and other ideas that often lurk in the background of our thinking about criminal offenses. See you next time.